Hi everybody, I'm Eric Riley, I'm the Pagan Librarian, and I'm here to talk to you about copyright law. So there was an incident that happened over the last week or so regarding a very popular Facebook group for the pagan community called Confessions of a Crafty Witch. And a lot of people got down on it and made a lot of comments, and a lot of those comments on both sides of the situation were coming from some somewhat ill-informed understandings of copyright law. So I want to throw out some general information about what copyright law is and how it is misinterpreted and misapplied, and ways that we can try to move forward so that we all understand what's going on, so that we in our own community know how best to approach this, and that we're respectful of each other and our creative endeavors as well as our creative boundaries. Copyright law has some very specific elements to it that you need to understand. So a work could be any number of things. It could be a book, it could be a poem, it could be an image, it could be a film, it could be an animated thing. Any number of things constitute a work that can be copyrightable. So a copyright gives someone, the creator of that work, exclusive rights to how that work can be used for a specific duration of time, and after that specific duration of time, the rights then become accessible to the public, okay? That's what we mean by the public domain. Exclusive rights means that the copyright holder has the exclusive privilege to determine how their work gets republished, reused, and in what context that they will allow you to make exceptions. So what is the duration of current copyright law? It is the life of the author, the entire life of the author until they die, plus an additional 70 years after that. That's quite a lot of time. So when does anyone get to use this other than the copyright holder? Well, the way that that works is that a copyright holder can license their work to you for a fee, or at their agreement for free use if they so choose. They own the rights, they control the rights. But the United States Constitution gives us certain exemptions that allow us to use certain copyrighted works in ways that allow for freedom of expression. And one of the most important parts of that is called the Fair Use Doctrine. So the Fair Use Doctrine gives you 4 specific areas where you can determine whether or not you can use an item that is a copyrighted item without repercussion. It depends on the purpose of the use of the item, whether it's going to be a non-commercial use or a commercial use, whether it's going to nonprofit or educational use. The purpose behind sharing an item or republishing an item or even reselling an item determines whether or not it constitutes fair use. Educational use, which is part of the purpose-driven component of the fair use doctrine, is one of the most commonly cited and commonly approved uses of copyrighted material. But the thing to keep in mind is that even though educational use allows you to reproduce copyrighted materials for the purpose of education, universities spend a lot of time and have copyright compliance officers that verify all of the material that they are using in their classes is considered fair use. And if they don't have compliance, then they don't use it. And that is a huge important distinction to make. You can't just copy a whole book and give it to your class and call it fair use. That infringes upon the exclusive rights of a copyrighted holder to the sale of their book. So you can copy sections out of a whole bunch of different textbooks and put it together into a course packet, and as long as it's small enough chunks of reproduced material, then the copyright holder will probably be okay with it. So the next section is the nature of the use. So is the new work something that is completely derived from the previous work, or is this something that is completely transformative? This is where we see things like exemptions for artistic exemptions, Jeff Koons is very famous for like his fried Barbies, right? This is one of those things where you put Barbie dolls onto like a tray and has them like with glistening oil or whatever under a lamp, like is this how Barbie is supposed to be portrayed? Probably not. But the fact that it was a completely original and transformative use of that previous copyrighted product means that the court could give it an exemption, and it did. And this is also where we see things like parody works. So Weird Al Yankovic has done a bajillion parody songs based on previous artists' works, but people aren't banging down his door to get royalties because the song that he makes is totally different and totally a joke based on the previous song. Now, he may pay licensing fees to Madonna and, Coolio or whoever that he's, appropriated a song from, but he still gets away with it because they're all parody, right? Now, there are problems with this in the music industry, and this is a big issue when you start to talk about things like sampling. And when you sample a work and you incorporate it into another work, it used to be that if it was just a small little component that had like de minimis standing, it was irrelevant. If it was like a beat pattern or something like that, then it wasn't a big deal. But that has since gone away, and the music industry is now having to license out all kinds of stuff that's being sampled, and it's really ridiculous. And there was a really great breakdown with the Beastie Boys album Paul's Boutique, and about how Paul's Boutique was like the pinnacle of pre-legal sanctioned sampling. Right? That if they had to go back and license everything in there, it would have cost them like hundreds of thousands of dollars, especially for the amount of attention that particular album got. So the next section is the amount of the work used. And so this changes a lot. I mean, so if we're talking about a giant textbook, if you're commenting on a section and you reproduce a paragraph and you cite that paragraph saying that this is from so-and-so's textbook, then that's a fair use example, especially if we're talking about things like criticism. But again, you can't cite an entire book. You can't reproduce the entire text of somebody else's work within your own work and call it your own. That's not cool. Now, there are exemptions to this as well. So, can you cite an entire poem? No, you can't cite an entire poem. Well, what if I just do a line or two out of a poem? Well, maybe, but what if it's a haiku? So this is really troubling, and it gets into a lot of murky territory. So one of the things that was cited in the Confessions of a Crafty Witch scenario was when people were posting spells on top of images from Dorothy Morrison or other people. So when you repost a spell, it's kind of like reposting a poem. In some respects, it can be like reposting a poem. And if you do the entire like incantation that's a part of that spell, then yeah, that's not cool. That's copyright infringement right there. But the weirdity in this is in recipes, because the Copyright Office gives you exemptions to reprint recipes, which are just lists of ingredients with impunity. Like you can just reprint recipes all day long, and it's not a big deal. But when you start to get into the instructions about how those things are carried out, and again, getting into the cost of spell work, yes, is you put all these ingredients together, you boil them for this amount of time, and you do this and that to them, and you say this, and that gets into copyright infringement. And so when people do that, it's a huge problem. I've seen this on other pagan sites as well, where someone had posted the entire text of some long piece from Ed Fitch's Crystal Well book, I was at a loss for it. I was like, why? How can you do this? Because they don't understand copyright law, or if they do, they don't care. The last really critical element is, how does this impact the value of the previous creator's work? So where the rubber really hits the road is when your copying and sharing of somebody else's copyrighted work cuts into their potential to make money from their own copyrighted work. And that's where we really need to start this conversation about where the copyright infringement in these pagan blogs and websites is coming from and how it impacts pagan authors and illustrators. So the first big problem that happened with the Confessions of a Crafty Witch blog was in relation to where they were sourcing their images from. This is one of the big ones, and that is a huge issue, not just for them, but for a ton of people on the internet. So a lot of people are under the impression that if there is an image that they can search and find on Google, then that image is in the public domain. This is a result of two terrible flaws. The first of all is that images that you search on Google are images that have been published somewhere already. So if they've been published somewhere already, then those rights belong to the people who published that image. That's the first one. The second is the misunderstanding of what something means what it means to have something be in the public domain. The public domain is actually a very specific period of time after which an image becomes freely usable, or an image or a piece of work or any kind of creative artwork becomes freely available for use and reuse and remixing without consequences. There was a very interesting scenario that happened actually fairly recently where a Christian pastor published a book on family values, and he used an image of a television family from the TV show Modern Family. I'm not familiar with the show, but I understand that in the context it was really hilarious because Modern Family is a show that deals with postmodern family values. And as this Christian minister was promoting pretty much not postmodern family values, it was kind of hilarious. But the bigger portion of this is that his book cover had this image that was a copyrighted image. And in his defense, he said, I got it from Google Images and I thought that it was in the public domain. Wrong, wrong, wrong. Google Images is a search engine, okay? If you find something on Google Images, it was published somewhere else. Don't use images from Google Images. There are plenty of different image sites that you can find that offer stock photos that you can either buy, license, and some of them are even in the public domain because people make images and put them in the public domain that are royalty free that you can use. They do exist. It is a thing that is out there, and you can find all kinds of really great websites to get free stock photography and free images for you to use in your either non-commercial setting or commercial setting with attribution or for free. Now, currently in the United States, and I'm only going to talk about the United States because that's what I know, that's what I was trained in library school. What the current public domain access here is 1923. Let that sink in for a minute. Okay, 1923. So this gets into a really interesting question about where do we draw the line at something that's considered public knowledge and something that's a copyrighted work. So Z Budapest is considered the titular author for the We All Come From the Goddess chant, right? And she has made very public pronouncements about how she does not want the We All Come From the Goddess chant to be corrupted into a male deity oriented song. And as potentially the copyright holder of that particular song, I haven't looked into it, she has the right to say that and the right to crack down on people that violate that. However, We All Come From the Goddess is something that is used in liturgy all the time. So where do we determine as a community where do we determine as a community when something is copyright and we need to respect the copyright holder and something is not and we don't? When you get into liturgical questions like that, it's really complicated. So, like, you have to ask yourself, who owns your religion? If we're looking at things like the Charge of the Goddess, which come from books that were written in the 1950s and then published in the 1950s and 60s, then we have to say, wait a minute, because if you remember, the copyright law, as I stated, at least in the United States, does not give the public domain access until 1923. So all of the works that we have, excepting some things from the Golden Dawn, and even some of the Golden Dawn works, are outside, are all inside the copyright realm. So, this is troubling for a number of reasons. But let's get back to the Facebook situation. So, macros and meme culture is one of those areas that has just never really been policed very well. Um, you wind up getting into some real oddball situations when you start to think about copyright law and meme culture. Meme culture is one of those weird things that it's a blend. Meme culture is a blended medium, right? It takes an image and it takes some text and you slap them together and you put them on the internet and you are publishing something. Now, think about this, okay? When you put something on the internet, you are publishing it. Okay? You are making it accessible for other people to see. You are, in some cases, selling other things or selling yourself at the very least, branding yourself. And when you share things on the internet, especially if you have a very large community, people will take notice of this. So, when you share music with your friends, this is the difference, okay? When you share music with your friends, the copyright law allows for a little bit of social sharing, right? You're allowed to, record some music and give a copy to a friend, right? This has always been the case, at least since the Betamax case came out in the 1980s and settled that whole thing, right? Yes, you are allowed to record television shows. You are allowed to record television shows to watch later with your friends and family in the comfort of your living room. Yes, you are allowed to copy your CDs and put them on your computer. Yes, you are allowed to upload your music to a cloud server and stream it over your phone. All of these things are legit uses of copyright. All of these things are legit uses of you copying your material and putting it someplace else so that you can get to it later. You are also allowed to share it with a limited number of people. So there's not a specific number of people. It's kind of like I can share to my friend over here and my friend over here and give you a copy of this album that I copied because you want to listen to it and you're broke. Okay, sure. The law is not going to crack down on you for doing that. There's options for you to share your Kindle ebooks with a friend who wants to read it. Not all of them do, but some of them do. But you can lend your friend your book, and the copyright people are not going to come knock down your door. That's all fine. Those are legitimate sharing uses, and that's always been protected, okay? So, where you get into trouble is when you start sharing things that you do not have the right to share with the world. Okay? So, when you have a Facebook page with 220,000 followers, okay, because you're awesome, you have a duty to recognize what it is that you're sharing and to make sure that you are respecting the copyright laws of your country where you are located and the copyright holder of the material that you're sharing, and making sure that whatever it is that you're producing and publishing, because that's what you're doing, you're publishing it, doesn't infringe on the potential for someone else to make money off of that work. So Confessions of a Crafty Witch has taken some steps. They've deleted a whole bunch of stuff out of there. They deleted the spell compendium pages, and I think that was a great step. They've deleted a whole bunch of other things that they didn't have attributions for. They started going back and reattributing things and, updating them and putting them back into the website with full recognition of all of the artists and all of the authors that were related to these pieces. And that is a commendable thing to do. The thing to keep in mind is that as you continue on in this process, if you start to make money on these things, then you're going to get into even more trouble, because commercial use and infringing upon the potential value of somebody else's material is where the courts will draw the line. And that's what you really need to know, is that once you start to cross into territory where you could be taking away from somebody else's commercial success, then that's where it's going to get nasty. Now, also too, that you have to really take in mind, the pagan community and the pagan publishing community is super, super small. It's very, very small. There are not a lot of pagan authors out there, and they are busting their asses trying to make a living at this, and not all of them are as successful as others, right? So when you share these things and you don't attribute them to somebody else, you are cutting into somebody's livelihood, and that is really an issue, right? So I listened to the podcast of Hex Education with Christian Day and Daw from Confessions of a Crafty Witch. And Christian Day talked about how when people were posting his material without his approval, that he started sending Digital Millennium Copyright Act takedown notices. And that is another method that you could get hit with if you start posting things that you don't have the rights to post. So, Digital Millennium Copyright Act talks about how people can infringe on the web and how we can prevent infringement through legal actions against other people. And it's super obnoxious for authors to have to go through this. It is terribly time-consuming, and especially for people in the pagan community that are not really making boatloads of money on selling these books, you need to be respectful of the fact that this is something that can take up somebody's entire life, eat up all their money and resources, and be a huge imposition on them, and could put an author out of work. Literally, it could put an author out of work to pay all these legal fees to deal with people infringing on their content. So here's where I kind of want to go with this. Like, there's a lot of different things that can be said about copyright. The really big things to keep in mind is that if something is out there on the internet, it's not a free-for-all, okay? Somebody owns the rights to everything that's out there, and you need to find out who it is before you post anything. If you don't have the rights to use somebody else's material, don't use it. Period. Start with the images, right? So if you're finding images, go out to a Creative Commons licensed place and get images from the Creative Commons, because they want you to use their images. Go for it. Go find things that are royalty-free, that appreciate attribution. You don't have to pay them anything. You just have to say, this image was produced by so-and-so at this website. Great. That's excellent, right? That's the place to start. That's the place to start, is by attributing your images and making sure that the people that you're getting the images from know that you're using them, that you have the right to use them. The second would be making sure that when you're using quotations, that you're using quotations that you attribute the author from whence those quotations come, right? If you're using a long piece of literature, check yourself, and say, is this a lot? Am I going overboard with this? Because, I'm probably going overboard with this. So check yourself, make sure that you're using a reasonable amount, and that you're citing the author from whence they come, and the source from whence they come, because citing the author and the source means that people will find that particular element and they will go back and want to look up that book and they will want to buy that book and talk to that person at the next big PantheaCon or whatever it is. And that's how you can help people, by promoting their stuff as well as respecting their copyright and not infringing upon their creative work. All right. So I hope that that was informative. I know that it's not perfect and it's not 1,000% legal advice. I'm not a lawyer. I'm a librarian. I have to deal with copyright issues as a part of my job and explain them to people. I have to explain them because I maintain a bunch of blogs, including blogs for a government agency. And so it's really critical that myself and my staff, that we know what we're doing with copyright. And I want you to know what you're doing with copyright so that you don't make a mistake and get slammed publicly, because that sucks. All right, take care.